tertiary competition. This evening's Moot competition is based on the theme of women in education. The Appellant is represented by the Fiji National University and the University of Fiji Port State. I would also like to take this time to thank each and every one of you for availing yourselves to be here this evening. We acknowledge the presence of our partners and supporters from the Ministry of Women, Children and Poverty Alleviation, Fiji Women Lawyers Association, the Secretariat of the Pacific Community, Ministry of Internal Affairs from Tonga, the Pacific Islands Foreign Secretariat, United Nations Population Fund, United Nations Women, Pacific Women, Fiji Women's Rights Movement, the Department of Foreign Affairs and Trade of the Australian Embassy, and the University of the South Pacific as well as the Fiji National University. And to our major sponsors, the Ministry of Women, Children and Poverty Alleviation, Fiji Women Lawyers Association, Unrelease Niche Farm Lawyers, and the University of Fiji. Now I will invite the University of Fiji President Student Association, Mr. Salazar, to give a welcome speech.
Thank you, Mistress of the Ceremony. I think it's time to welcome each and every one of you this evening. And thank you for joining us in this round of the competition. I also would like to acknowledge the presence of the two teams who will be competing, and that is Fiji National University and the University of Fiji. And we wish them all the best in their participation this evening. And for the rest of us, we hope that you will continue to support this initiative. On that note, I welcome everyone once again to the University of Fiji. Thank you.
Now I shall invite Mr. Appellant to the stage.
Good evening all. It is my humble honor to introduce our panel of judges for this evening. First we have Ms. Sharma. Ms. Sharma is a partner at Neil Shivam Lawyers and a graduate of the University of the South Pacific. She joined legal practice in August 1999. Ms. Sharma heads NSL's litigation team and specializes in civil and commercial litigation with emphasis on contract law, intellectual property, labor and employment, personal injury insurance, industrial law, industrial arbitration and disputes. She also practices at appellate levels, including the Supreme Court of Fiji. Prior to joining Neil Shivam Lawyers, Ms. Sharma worked as a private practitioner in locally renowned law firms. Ms. Sharma is a member of the Law Association for Asia and the Pacific, a leading international professional association for lawyers in the Asia-Pacific region. Ms. Sharma has previously served as a management board member with the Fiji Women's Rights Movement. Secondly, we have Ms. Melia Thai. Ms. Melia Thai graduated with Bachelor's in Law degree in 2007 and completed her first professional diploma in legal practice in the same year from the University of the South Pacific. After admission to the High Court in August 2007, she joined Jamnadas and Associates, where she practiced mainly in commercial law and family law for more than 4 years. Ms. Melia has also worked as a prosecutor in the Legal Practitioners Unit under the Office of the Chief Registrar's Office, which regulates the legal profession in Fiji. Ms. Melia joined Sharani & Co. in early 2012, where she practices a wide range of civil and criminal law, but handles majority of the firm's employment matters. Ms. Melia has also continues to engage in general practice, but specializes in commercial, property, family, and employment law. Apart from practice, she is the current president of the Fiji Women Lawyers Association, taking over from former colleague of the firm, Ms. Radhika Naidu. Women's and children's rights are human rights issues Ms. Mele is concerned about in Fiji. Ms. Mele is also a board member of the Legal Aid Commission and the Fiji Girl Guides Association. She also contributes to the World Bank Group and has volunteered with several charity groups, namely the Hibiscus Events Group, Gender Climate Change Alliance Fiji, and Gospel Churches Missions Committee. Thirdly, we have Ms. Nikita Narishma Pratap. Ms. Nikita was admitted to the bar in 2016 and spent 3 years serving at the Legal Aid Commission as a legal officer before she decided to leave the firm to learn more about women's human rights. This passion followed from working with women and children in family matters. She joined the Fiji Women Crisis Center in 2019 as a legal officer. She learned about patriarchy, which is the root cause of violence against women and girls in all spheres of society. She is finding her place in feminism and is immensely enjoying the work on the elimination of violence against women and girls. While her passion for helping women and girls continues to grow each day, she also has a passion for watching scary movies with her 6-year-old brother, Ryan, and she is more scared than he is. Thank you.
Now I invite Ms. Sam to deliver the report judgment from last week's competition.
Hi, first of all, I must apologize for my tie. I didn't expect to be standing up here in the morning. So just in regards to the judgments, I have not written any down, so I must apologize for that in advance. Secondly, in regards to round 1 of the Moot competition last week between the University of South Pacific and the Fiji National University, I find in favor of the University of South Pacific. And I think it's fair that I also explain how the marks were given. Now please understand that the marking criteria is according to the mooting manual that we were given. We've gone through it, and based also on the submissions as well as the presentations that both teams had given. Regardless who I had found in favor of, both teams did extremely well. Now, in terms of the University of South Pacific, for content, which was 40 marks, I had given them 28 out of 40. Now, the reason for that, I realized that in the mooting manual itself, it gave the format. And the format that was used by University of South Pacific was the wrong one. Second, the appeal grounds were not highlighted well or clearly in the submissions. And they needed more persuasive case laws because I found that they referred mostly to the ones that were in America, ones that were in Canada. And also, while they were well versed in terms of the main case that they had relied on, they didn't know the case well. So while what they did was pick certain points, relied on that paragraph, but didn't take the whole case into account. There was also accurate citation in terms of how you put the case laws and how the submissions were put in. Now, that was for content, 28 out of 40. For presentation, it was 28 out of 30 because they're quite articulate, especially the third council. They guided the court through their submissions. So as they made their submissions and they said, I would like to refer the court simply to refer the court to tab 1, paragraph 3. So it was a good way of at least guiding the court through their submissions. They were also confident, all three councils, they admitted their limitations, so when they didn't know anything, especially the second council, he admitted to not knowing, so he didn't evade the question, he was honest. And it's always important to remember dressing. When you go to court, there are some judges and magistrates that are very particular about the way you dress. So even if you're coming to sit with bench, always wear a coat and always remember to button up. Ability to answer questions, I've given them 29 out of 30 because they have never flustered during questioning. They're quite composed. Not once did their voice go up, go down, or did they stop. We even had first counsel who stared me dead in the eye and said, oh, my lady, can I proceed? And they were very concise in their response, especially the third counsel. They never lost track of their main argument, but they may need to read their main case that they're relying on heavily better, especially the one that you want to let the court know that this is the precedent in this area, and can we follow this? And they need to know that case inside out. So overall, I give them 85 out of 100. For FNU. Now for the content, like I had given my feedback last week, it was well done. The format was correct, the submission was written well. They also needed more persuasive case laws. And you also need to know and prepare for possible responses to the subs, because when we were going over the submission, we realized that you just took a paragraph, and while you knew that this was a precedent case that the whole scenario was based on, didn't really read into it. So you just took the paragraph that was there and left it as that. Also, what was very impressive is while the appellants didn't have an appeal ground highlighted in their submission, the respondents had already put in to say this is the appellant's appeal ground. So that was quite impressive. So for that I gave 38 out of 40. Now presentation of argument, which is out of 30, I said overall it was a good try by the two counsels. They were very professional, and when they were not flustered, they were clear on their grounds. I think it's also important the next time guide the court through their submissions, especially when you're referring to case laws that you are submitting to the court. So you got 25 out of 30, which was pretty good, and I think you did pretty well. It was the only ability to answer questions where you lost a lot of your marks, and I've given you 15 out of 30. The reason being, one, you were not composed. Second, while you were very confident, and I could see that in your presentation, there were points where you let the questioning get the better of you, and you would all sit down and then count them together, and needed a bit more encouragement or insistence from the court to stand up and come back to the lecture. Unfortunately, in the real world, we don't have that luxury. So, and I must say, and I've written here, counsels are very confident, and you need to trust in your submission, and you need to trust in yourself, because I can say you're very articulate as well. But it's just as soon as the question started fighting, you lost confidence in both the submissions that you made, which was well written, as well as your point of argument. And you got a total of 78 out of 100, which isn't far from the 85, so I think you did pretty well.
All right. Representing judges, Her Ladyship, Justice Shoma David, Her Ladyship, Justice Malay Rakai, and Her Ladyship, Justice Nikita Pratap. In the controversial matter between Meren Bromro and the state, case number 2 of 2021.
May it please this honorable court, counsel's name is Chan, first initial J, appearing with my co-counsel Monelewu, first initial J. We enter an appearance for the appellant.
Thank you, Chan.
May it please this honorable court, your ladyships. Counsel name Dina Nilarata, initial S. I am appearing with co-counsel Wakatutulu Angani, initial S, and co-counsel Praniga, initial P.
This counsel for the appellant.
If it may please you, my ladies, we seek leave of the court to submit a copy of the submission with the backing. We apologize for the oversight.
We have a submission.
May I proceed with the...
Yes, you may proceed.
Your Ladyship, the appeal is based on three major grounds. The appellant is appealing on the ruling of the High Court on the following grounds. The learned judge erred in law. The learned judge erred in law in allowing the striking out when the case would affect thousands of students all over Fiji, especially young female students such as Mary Dondro. In allowing the striking out without hearing the plight of Mary and other students is denying them a right to be heard on their claim contrary to their constitutional rights. In allowing the striking out by the defendants when the government had not shown that it lacks the resources to continue educating students who want to enroll in MBBS, oral health, dentistry under the National Topper Scheme 2021. If it may please this Honourable Court, the appellant would therefore like to make the following submission. According to ground 1 of the appeal is that the learned judge erred in law in allowing the striking out when the case would affect thousands of students all over Fiji, especially young female students such as Mary Dondro. The appellant respectfully submits that the provisions of the 2013 Constitution of the Republic of Fiji are clear on the right to education. We respectfully guide this Honourable Court's attention to tab 1.1.1, where section 31 verse subsection 1 states every person has the right to early childhood education, primary and secondary education and further education. Furthermore, the provisions of section 31 subsection 2 states as follows: the state must take reasonable measures within its available resources to achieve the progressive realization of the rights to free early childhood, primary, secondary and further education. The above provisions establish the government's constitutional responsibility to ensure that every child has the right to education, and this includes further education beyond secondary education. In the case of Ms. Dondro, this means tertiary education in the field of medicine. The appellant respectfully submits that an individual's right to education is vital in determining their growth in life. The appellants refer to the case of Mohini Jain and State of Karnataka, where the Supreme Court of India decides that the right to education be read as an integral part of right to life guaranteed under Article 21, Part 3 of the Indian Constitution. The decision of the court that the fulfillment of the right to life requires a life of dignity and therefore must be interpreted to include economic and social rights extended by the Indian courts to ensure rights to food, water and health. Ms. Dondro has the right to education, further education, and that right has been inaccessible to her due to government's unfair and unconstitutional decision. In any other circumstances, Ms. Dondro, the daughter of a cane cutter, would not be able to realize her dream of becoming a doctor.
Mr. Chan, if I may pause you there. In terms of your case, proceedings were filed against the chairman of the board, that is the Tertiary Scholarships Loans Board, against the Minister of Finance and the Prime Minister. In terms of the Act, which is the Tertiary Scholarships Loans Board Act of 2014, do you consider that these persons who you have named are proper parties to proceedings?
Yes, Your Ladyship.
Yes, and why do you say that? What are your submissions of that?
The Prime Minister, the Attorney General's office, it was through them through which the loan scheme was, the ATS and the TELS loan scheme was suspended, and they had mentioned that there was lack of resources, but they didn't further explain where there was lack of resources. That's it.
Would you consider under the Act that the proper party should have been the board and not the chairperson in his capacity as a proper party to the proceedings?
Your Ladyship, to answer your question, the board wasn't party of suspending the loan scheme. It was the government and those parties involved.
Yes, may I proceed with the submissions, Mr. Chair?
Your Ladyship, Ms. Dondro has the right to education, further education, and has the right, and that right has been made inaccessible to her due to government's unfair and unconstitutional decision. In any other circumstances, Ms. Dondro, the daughter of a king cutter, would not be able to realize her dream of becoming a doctor because the scholarship that she was applying for was suspended. This brings me to the end of my submission. If your Ladyship has no further questions for me.
Yes, I just have one final question. In terms of the remedy that your client is seeking, that is declarations, would you consider that under the Act, your client has alternative remedy to pursue, that is to appeal to the board?
No, your Ladyship.
And why do you say that?
Because the board was not involved in the suspension of the loan scheme. Your Ladyship, may the co-counsel proceed with the next part of the submission.
If it pleases this Honorable Court, may I proceed with submission 2.2 and submission 2.3. Before I proceed any further, we seek leave of this court to dispense with paragraph 2.2.6. Therefore, we will not be addressing that point. Your Ladyship, in allowing the striking out without hearing the plight of Mary and other students is denying them a right to be heard on their claims contrary to their constitutional rights. The striking out of Ms. Dondro's case in the High Court violated the appellant's right to be heard, a fundamental principle of human right, and it is a contradiction to the principles of natural justice. Your Ladyships, the right to be heard or audi alteram partem is a principle of natural justice. According to this principle, no man shall be condemned unheard. Under this principle, no person is to be judged without a fair hearing, and where each party is given the opportunity to respond to the evidence against them. Your Ladyship, this opportunity, or in this case, Ms. Dondro's right to be heard was struck out without any justifiable reasons. The denial of the right to be heard affects not only Ms. Dondro but numerous students, especially young women, who are already at a disadvantage. Your Ladyship, it is also respectfully submitted that the Universal Declaration of Human Rights, to which Fiji is a signatory member, echoes this fundamental right in Article 26, respectfully guide the Honorable Court's attention to tab 2.1.1, whereby Article 8 states that everyone has the right to education. Technical and professional education shall be made equally accessible to all on the basis of merit. Your Ladyships, the appellant in this case has scored 390 over 400, thus putting to rest the question of merit, making her more than eligible for the topper scheme, and at best making her eligible for loan schemes, as legislated by the Tertiary Scholarship and Loans Act 2014. Your Ladyship, as per the facts, Ms. Jonjo's father is a cane cutter and therefore cannot afford to privately send her daughter to school to be a medical professional. She cannot pursue MBBS under or privately, that is, Your Ladyship. Additionally, Ms. Jonjo's mother had died to a rare disease, after which it had become the appellant's dream to become a doctor. Your Ladyship, we submit that in allowing the striking out, the judge denied Ms. Jonjo's right to be heard. This is a violation of a constitutional right. Furthermore, it is respectfully submitted that the decision made is in breach of Article 13C of the International Covenant on Economic, Social and Cultural Rights, which states as follows. We respectfully guide the Honorable Court's attention to tab 2.1.2. Forgive me. Yes. I believe it's forgive us for our oversight. It's an error on our part. Would you like it, ma'am?
Do you have copies for them?
Yes, Your Ladyship.
Give Ms. Candida.
Pardon us, Your Ladyship, for this oversight. I would like to.
Which tab are you on?
Currently, I'm on tab 2.1.2. With the Ladyship permission, may I start over?
Counsel, if I may, just stop you right here. Unfortunately, the file given, the submissions given to the bench, there is not tabbed. At least my copy is not.
Once again, pardon us for our oversight. I would like to guide this Honorable Court's attention to tab 2.1.2. Furthermore, it is respectfully submitted that the decision made is in direct breach of Article 13C of the International Covenant on Economic, Social and Cultural Rights, which states as follows. Higher education shall be made equally accessible to all on the basis of capacity by every appropriate means, and in particular by the progressive introduction of free education. Your Ladyship, Mary has met the standard of merit. However, the government has given no justifiable reasons in cancelling the scheme for medical students. In fact, it is our submission that this could have been dealt with by the High Court, but the matter was struck out, denying the right to parties to be heard and to prove its case. Your Ladyship, moving to our third round of appeal. In allowing the striking out by the defendants when government has not shown that it lacks the resources to continue educating students who want to enroll in MBBS, oral health and dentistry under National Doctors for 2021, The judge erred in law under Section 31, Subsection 5 of the Fiji Constitution when the court dismissed the case with no provision of proof from the government for not having the available resources to fulfill its obligation under this section. Moreover, Your Ladyship, in the case of Thomas K. Budd and the State of California, the court decided that the government is responsible to uphold the fundamental rights of students to education. I would like to guide this honorable court's attention once again to tab 1.2.2. In the case between Thomas K. Budd and the State of California, it is stated that the state itself is responsible for the fundamental education and educational right of students and must remedy a local district's inability to provide its students an education. Your Ladyships, I would also like to guide your attention to tab 2.1.1. As per Article 8, the Universal Declaration of Human Rights, a convention that Fiji has ratified into its constitution, it is provided that everyone has the right to an effective remedy by the competent national tribunal for acts granted to him or her by the constitution or by law. Your Ladyship, this is a remedy that was denied to Mrs. Dronjo. Furthermore, it is respectfully submitted that the court erred in law when it did not offer an alternative as provided in Section 31, subsection 4 of the Constitution, which states that the state must not take reasonable measure within its available resources to achieve the progressive realization of the right to free early childhood, primary, secondary, and further education. Your Ladyship, the appellant submits that not only was Ms. Dronjo's fundamental and constitutional right to be heard denied, but an alternative course of redress had also been denied. If your Ladyship has no further question, I would like to proceed to the prayer.
I have one question for you. Now, in terms of the relevant section, which is Section 31.5 of the Constitution, what are your submissions insofar as the respondent's case is concerned, that they have pleaded that the pandemic affects the ability to put up resources to fund the scholarship? What is the submission about that?
Your Ladyship, we still stand by that. It's not a justifiable reason to cancel the scheme for medical students. If anything, we need more doctors, Your Ladyship.
And why do you say it's not a justifiable reason? How do you qualify your submission?
Your Ladyship, we do not have any proper evidence of why they cannot have, why they have to cancel the scheme for medical students.
So your submission is there's no proper evidence,
yes,
insofar as the effect of the pandemic is on the state's resources. Is that what you're saying?
Yes, Your Ladyship. If it pleases Your Ladyship.
No.
Oh, sorry.
Counsel, I have a question for you.
Yes, Your Ladyship.
Now, you have mentioned in your submission in paragraph 2.2.5 that the appellant scored a mark of 390 out of 400 and therefore was eligible under the Tertiary Scholarship and Loans Act for the scholarship, correct?
Yes, Your Ladyship.
Now, and in your submission, I read for paragraph 2.2.1, and you're submitting that by striking out the application, the appellant's right to be heard was taken away.
Your Ladyship, could you repeat
In
the
your
question?
paragraph, in the submission submitted before the court, paragraph 2.2.1, you are submitting that by striking out the application of the appellant, the right to be heard has been taken away.
Yes,
Now-
Your Ladyship.
Now, could that be remedied if that application to reconsider the application would be put before the the TELS board?
Your Ladyship, the TELS board wasn't involved. It's directly, this scheme was removed by the government.
Council, if I may, you have referred to section 31(5) of the Constitution, and the basis of your appeal is that, as the appellant for Ms. Dronro, is that the state hasn't shown any proof.
Yes, Your Ladyship.
So, TELS has made a decision in January this year to suspend all funding. So it's not a final decision, it's a suspension of all funding for all MBBS students, all students enrolled who want to enroll for the oral health dentistry program with the School of Medicine. Okay, so they've said that we've got more than enough doctors. Okay. Why is it that you as the appellant is saying that the government or the state hasn't shown? What exactly are you saying that the state is not showing? Is that not enough, that we have so many doctors?
Your Ladyship, may I have a moment to consult with my co-counsel?
Sure. Counsel, I'll just rephrase my question. My question is, as I take it from your submissions, you're saying that the state is not showing its responsibility. Okay, I'll rephrase a bit about the doctors, but you're saying your complaint on the government or the state is that they're not showing, they're not giving proof. Is that what I take it from the first speaker and as you counsel? That seems to be your complaint. Your complaint is the state is not showing resources, that it lacks the resources, and the first charge is asked you that no, we're in a pandemic. So what exactly what is your complaint if they're saying that they don't have resources? The government is saying we don't have the resources, we're in a pandemic. What more are you saying that government should provide?
Your Ladyship, just a reason as to why they are not giving it for MBBS up, like under the they are not giving any reason. Your Ladyship, forgive me, I may not be able to.
Perhaps I rephrase my question. When you're saying that the state is the state is not showing enough, what exactly are you saying? Because you are the appellant. You've moved the Court of Appeal to have 3 judges to hear your appeal on behalf of your client, and you're saying thousands of women. So you're saying all these women that are in the auditorium today in this courthouse, they're interested in this case. So what is it that the appellant is complaining about that government should show? That's really our question, because government is saying, I'm sorry, we don't have the resources, we're in a pandemic, we are unable to fund this program. We're not saying we're canceling the program, we're just going to suspend it. For how long, they've not stated. They're just saying suspension from January this year. So what exactly is your complaint on that if government has said that?
Your Ladyship, I apologize, but I may not be able to assist the court with this matter.
Perhaps to get some clarity on submissions. In terms of the requirement under the Constitution, the state bears the onus to show that it does not have resources to fund the scholarship. Now, in terms of your client's case, what would be your submission that what evidence should have been produced before the court to satisfy the requirement under the Constitution?
Your Ladyship, preferably a budget.
Well, I'm just wondering, I'm looking at the cases you've referred to, both councils. You have referred to cases from California, and in respect of the other case, you referred to cases from India. Any reason why we don't have any local authorities? Because you understand they're of persuasive value only. Any reasons why there's no referral to a local case?
Oh, Your Ladyship, we couldn't find one. Your Ladyship, may I proceed with the press? The appellant therefore respectfully submits that in considering the above laws and principles, the judge did err in law in striking out the matter and not granting leave to appeal when it clearly contravenes the provisions of the Constitution and the International Human Rights Convention to which Fiji is a state party. We therefore pray to the sensibility of this honourable court and respectfully seek the following orders. Firstly, that the appeal be allowed to pursue the matter and seek redress, and that the respondents bear all costs. If it pleases Your Ladyship, that will be all from the appellant.
Before I commence, I seek the court leave my ladyship to serve a copy of our submission to the court and to the appellants.
We were previously provided with a copy of the respondent submission. Are those supplementing the submissions that you have already provided?
They all the same, no?
They're all the same?
Yes, the leadership.
We don't need copies then. I mean, shall we do the copies of the submission?
We have a additional case.
Additional cases.
Sorry,
Have you provided copies to your opposing counsel?
My ladies, we make an appearance for the state, who are the respondent for this matter. The appellant has raised 3 grounds of appeal to which we would like to respond, and the 3 grounds are as follows. The first ground is the High Court has struck out the case when it will affect thousands of students around Fiji and including the appellant. The second ground of appeal is that the appellant has been denied our right to be heard contrary to the constitutional right. Lastly, the ground of appeal, my ladies, is that the High Court allowed the striking out of the case by the defendant when our client has not shown it lacks of resources. We, the respondent, will submit 2 grounds. The first being the abuse of process. Secondly, denial the right to be heard. My ladies, I will be covering on the first point, the abuse of process, while my co-counsel will touch on the second point of our submission, denial the right to be heard. May I draw the court attention to the Tertiary Scholarship Act, Loans Act 2014, Section 80, subsection 2. My ladies, the respondent submits contradicting submission by the appellant contrary to Section 13 of the Tertiary Scholarships and Loans Act 2014. That there is an absolute presence of abuse of process. The respondent submits that there are alternative remedies are available to the appellant to exhaust before bringing the matter to the High Court. In Section 13, subsection 2 of the Tertiary Scholarships Loans Act 2014, which specifies, and I quote, that any person aggrieved by the decision of the board may appeal to the appeal committee provided. However, all the decision of the board in relation to the awarding of the scholarships and laws under this act shall not be subjected to the appeal, unquote.
Mr. Levitt, I'll support you there. In terms of section 13 of the Act, is it not correct that the decision to suspend the scholarship was made by the state and not the board?
May I rephrase the question again, lady?
Is it not correct that the decision to suspend the scholarships was made by the state, that is the government of Fiji, and not the board?
The decision to suspend the scholarship is made by the government.
Yes. So it's made by the government.
Yes.
Therefore, does section 13.2 then apply? Or can the appellant then rely on section 13 subsection 2? Raise submissions of that, Council.
That any person aggrieved by the decision of the board may appeal to the appeal committee.
Doesn't it say decision of the board?
Absolutely, Madam. Okay.
So what are your submissions? Does it apply or does it not apply? Given that the decision is not by the board, it's by the government.
It's by the board, my ladies.
So
Pardon me.
your submission is that the board has made the decision to suspend the scholarship?
That's correct, my ladies.
And not the government?
Yes. The appellant could have appealed to the appeals committee under the provision of aforementioned for change in the decision of the Tertiary Scholarships and Loans Board pertaining to the uses of suspension of the MBBS, oral health and surgery program. My ladies, we would like to invite the court to look into the case of State and Public Service Commission ex parte 9. I'm aware that this is the High Court matter and this court is not bound by the decision of the High Court. However, your ladies, we have cited this case for purpose only to portray that there is an appeal board that listen and consider grievances for civil service. As such, we humbly request to use it as persuasive authority, in which the abuse of process highlighted which should have been followed by the appellant. In highlighting the processes, the court referred to the Public Service Act 2014, which stated that there was a public service board where the applicant did not follow proper channel by appealing to the board. Instead, the appellant went straight to the High Court and filed an action. Similarly, Tertiary Scholarships and Loans Act 2014 establishes the appeals board to which the appellant should have appeal first before bringing the matter to the court. In the matter of application by the Fiji Service Association for leave to apply for judicial review under Order 53 of the Supreme Court, may I draw the court attention on page 3 of the Supreme Court paragraph, the 5th paragraph. The copies that have been submitted are being highlighted. Before I elaborate my next case, I would like to humbly inform this honorable court that my next case this evening, my ladies, is a matter of application by the Fiji Public Association for Legal Judicial Review under 53 of the Supreme Court. Within the context of this matter, it was quoted Section 13 of the Public Service Act Cap 74 establishes the Public Service Commission right of appeal to the board arising out of promotion, punishment, and transfers of offices in the public service. Subsection 2 of Section 14 empowers the minister responsible for the public services to exclude the right to any offer or position specified in order made by the minister. My ladies, clearly the appellant has abused proper process that was already been established by the Tertiary Scholarship Loans Act, to which she should have appealed first before bringing the matter to court if it is still unsettled. My lady in entirety, the court is well equipped to hear such matters, provided proper process and procedures has been fully exhausted. And it is clear the appellant failed to do so. At this point, I have come to an end of my submission, and at this point, I'm happy to answer any question if the court may have for me.
I have one more question for you.
Thank you.
Given your submission that the decision was made by the board and not by the government, what are your submissions? Where are the board's powers derived to suspend a scholarship? Are you able to direct us to the relevant section?
Pardon me, my lady, may I seek leave for this honorable court to discuss the question with my co-counsel? Thank you. My ladies, if I may correct the statement made by myself, the suspension of the tertiary scholarship for MBBS had been decisioned by the board and not by the government. Thank you.
It's made by the?
By the board.
Right.
And not by the government.
Right. So then you still proceed with the submissions insofar as Section 30 is concerned?
Yes.
I'd like to ask a question. Can you hear me?
Yes. My ladies.
Okay. My question is that where does the board get its powers from? I think that's what Justice Devon was asking you. Where does the board derive its powers from?
The board have its own.
Wouldn't you agree with me that the board derives its power from the Prime Minister and the Attorney General, who's also the Minister of Finance?
Yes, your ladyship.
So your position, the respondent's position is that this application has been filed by the appellant is an abusive process.
Yes.
And the reason why you say it's an abusive process is because they didn't exhaust the internal appeal provision in the Act.
That's correct, your ladyship.
But when the decision, wouldn't you agree with me when they delivered the decision to suspend the national toppers and the scholarships in relation to MBBS and oral dentistry and etc. for the School of Medicine, that was a decision that really was coming from government? What do you answer to that?
Yes.
Okay, so does your position still stand that they've done the right thing, they've come to the High Court seeking a relief before the High Court?
No, my lady.
You still stand by your position, even though you do understand the board derives its power directly from government, so to speak.
Yes, my lady.
I have no further questions, Justice.
Mr. Deveta, in terms of the board, when I say the board, I'm referring to the Tertiary Scholarships Loans Board. It is a statutory body set up pursuant to the Act. Would you, what are your submissions, this was the question that I had earlier asked, if the decision has been made to suspend the scholarship by the board, what are your instructions? Where did the board derive its powers to suspend?
from the Ministry of Economy, Melody.
Are there any statutory provisions contained within the Act that empowers the board to make a decision to suspend any scholarship? Have you considered that in your submission?
Yes.
And what is your submission?
Basically related to the board has an appeal committee provided. However, all the decisions of the board in relation to the awarding of scholarships and loans and that these acts shall not be subjected to an appeal.
But that is the student's right to challenge a decision that is made. My question to you is, if the board has made a decision to suspend the NPS scholarship, where has the board derived its power to suspend?
Pardon me, my lady.
If you are unable to make a submission on that, you can say so.
I won't be able to make a submission on that.
I mean, you're the respondent, you're coming on behalf of government. Is there no empathy for these young ladies? Is there no empathy for the students that would be so affected by this decision? You're coming for government as the respondent. You're simply saying this application is an abuse of process. That you're a board that's answerable to the people, and this kind of decision affects we're not talking about only the appellant that's here. We're talking about thousands of girls, thousands of young boys whose dreams would be stopped, curtailed, stopped by this kind of decision. Is there no empathy on the board? I mean, probably may not relate to the ruling, but
we did not deny the right to education.
But you denying the appellant the right to pursue her dream, which is to pursue a degree in MBBS medicine.
We didn't deny the right to education, however, we still have the scholarship continue for other programs.
Now, following up from that question, you've heard the submissions by the appellant. Do you have were there any statistics, any documentations, or any numbers provided on the decision, on the rationale of the decision that the board made?
Pardon me, my lady, we don't have a media statistic.
In your folder, the documents that you provided. Or is there another speaker that will present on the document?
I believe there's another speaker.
There's another speaker. Very well. Then I'll ask that speaker that question. I have no further questions.
I now seek leave this honorable court to execute the battle. Thank you.
Good evening, my ladies. Before I proceed, I would like to apologize on behalf of my co-counsel. The questions that have been asked to him, I would just like to clarify. We have not provided your ladyships with a copy of the media release that states that the board had suspended the funds pertaining to the scholarship award to MBBS. If I may proceed with my submission. My co-counsel had highlighted on the first point being the abuse of process. In addition to this, my ladies, we, the respondents, would like to raise another point, the denial of the right to be heard. My ladies, the respondents submit that we stand by the decisions of the High Court in denying the appellants the right to be heard. Contrary to their constitutional rights, this, my ladies, we submit and re-emphasize upon this honorable court that there were no proper procedures that were followed pertaining to this case. The appellant had not exhausted her remedies which are available to her under the provisions of Section 13, subsection 2 of the Tertiary Scholarship and Loans Act 2014, in which establishes the office of the Special Boards Committee that deals with the appeals. The appellant's second ground of appeal, which is the right to be heard, we submit that this issue is not a matter of the proceedings of this court. The appellant's right to be heard would have existed in the Appeals Commission under the relevant provision provided in the Tertiary Scholarship and Loans Act 2014, which in this matter, your ladyships, clearly the appellants have bypassed. The appellant should have resorted to this ground first before even filing the matter to the High Court. In addition to this submission, my ladies, the right to education under Section 31, subsection 2 of the 2013 Constitution, if I may direct the Court's attention, it states, and I quote, "The state must take reasonable measures within its available resources to achieve the progressive realization of the right." The appellants have argued on the basis of the right to education. However, we, the respondents, submit before this honorable court that the provisions under Section 31, subsection 2 does not make this right absolute. Contrary to the Appropriation Act 2020-2021, the allocation of funds for every financial year is such that our client does not prioritize the needs of one functioning ministry, nor an independent body, nor commission, nor even a single person for that matter.
I'll just pause you there, counsel. Now, insofar as the evidence that was in the lower court, the respondent had not offered any evidence to show that he did not have the resources to provide the scholarships. The respondent has really relied on the pandemic to say that it cannot put together resources to fund the FTS scholarship. What are your submissions on that? Can you effectively rely on the pandemic to say that you do not have the resources?
My ladies, as provided within the Appropriation Act, we, the respondents, submit that the government caters for the rights and the needs of all the people of the country, and it does not focus or prioritize the rights or just an individual right for that matter.
You have not answered my question, Councillor. Now, insofar as the respondent's submission is that it relies on the pandemic to justify the suspension of the scholarship. What are your submissions insofar as that position is concerned for the board, for the government?
Your Ladyship, our client at the moment tries to sustain the country's economic status, considering the current pandemic that we are currently going through. Therefore, under the Appropriation Act, it tries to allocate funds to each ministry and not prioritize or uphold the needs of just one functioning ministry, nor a single board or a single person. So the main point is that the government, our client, my ladies, is catering for the needs of all the people of the country. If I may proceed. The Appropriation Act 2020-2021 binds the allocation of funds to each ministry and makes it final. Our client caters for the needs of all the people of this country, whether it may be those farming in the very hot sun in Lambasa, to those in the very cold maritime areas of the Lau Islands, and even the redundant hotel workers alongside the Queen's Road. Our client, my ladies, at the moment even tries to continually sustain the country's economic status, considering the current pandemic that the country currently faces. Therefore, my ladies, we submit that under the Constitution, there are clusters of rights, and not only the right to education. Our client cannot uphold the needs of just one particular person, nor the collective few, but it has to weigh out against the interests of the wider public. Section 31, subsection 2 of the Constitution guarantees that the right to education is not absolute. provided the government takes reasonable measures within its available resources. In light of the discussions alluded above, we, the respondents, empathize with the appellants. However, firstly, I would like to stress that they had not followed the proper procedure in which was available to them, established under the Tertiary Scholarship and Loans Act 2014. And also, secondly, that they were denied the right to be heard on the basis that there was a presence of abuse of process. And thirdly, the right to education is not absolute, my ladies, contrary to the provisions provided under the Constitution. If I may, if the court does not have any questions, can I proceed with the prayers?
You're saying that so I take it from your submissions that the state is trying to look after everybody,
Yes,
not
yes.
specifically one person, or which is this appellant, Miss Mary Ronro. It's trying to look after everybody. But I'll reiterate, in the lower court, you did not prove or you did not show that you did not have the resources. Your main argument in the lower court was that it's a pandemic and we have pressing issues to attend to. That's all. This appropriation gazette that you're trying to submit to us was not dealt with in the lower court. Have you provided a copy to your friends?
Yes, Your Ladyship.
So, if this wasn't provided in the lower court, how are we supposed to deal with that now, on the day of the hearing? You did not prove that before the lower court who dealt with this matter.
Your Ladyship, if I may answer your question, our respondent submission we are responding to the appellant's grounds of appeal.
Okay.
Yeah, they have 3 grounds of appeal that we have formulated and responded to, contrary to the processes that were involved and were not followed, and also the right to education.
I'll repeat my question. The burden is on the state to show that he did not have the resources. And in the lower court, you did not prove or you did not show you did not provide any evidence that the state lacked the resources to make such a decision. To suspend funding in respect of this particular program.
Yes, Your Ladyship.
Okay. So, if you didn't provide that information to the lower court, wouldn't you agree with me that that is why the appeal is before us now?
I would agree to that, Your Ladyship.
Yeah, no further question.
Also, you have mentioned about right to education not being absolute.
Yes.
So while the government needs to take appropriate steps towards realization of the right to education and making available resources for it, you agree that lack of resources cannot justify inaction of the government to implement that right.
If Your Ladyship could repeat the question.
While the state has to take appropriate measures in order to ensure that full realization of the right to education should be available for everyone, then lack of resources cannot justify to postpone or delay that right. Now, when the state is saying that and in your case you have submitted to the court that due to the pandemic, the state is unable and there is a reason for suspension of that scholarship. Now, apart from saying or relying on the current pandemic situation, what is the state's position, or rather how is the state going to prove what has happened during this pandemic that has made it impossible for the state to deliver to that right?
Thank you for the question, Your Ladyship. As provided within the Appropriation Act, there are allocation of funds to all the ministries and the statutory bodies under the Appropriation Act. Therefore, pertaining to your question, for the right to education, that right would be exercised under the statutory body of TELS, Tertiary Scholarship and Loans Act, my lady. However, the respondents submit that under the Appropriation Act, the allocation of funds is to every ministry and not just focusing on just one ministry, which is in this case would be the ministry responsible for the Tertiary Scholarship and Loans Board. So we are trying to, on behalf of our clients, they are trying to disseminate the finance available to all sectors of the government and not just a single body.
Council, the appellant's submissions are that there was no evidence provided by the respondent to show that it did not have resources to fund the scholarship. The appellant's submissions are that there was no budget presented as evidence before the lower court. Certainly you speak of the appropriation bill, appropriation act, and you submit that there are allocations of funds for different ministries, different departments. Insofar as the allocation of funds is concerned, was this submitted in the lower court as evidence?
No, Your Ladyship. This has just been submitted before Your Ladyship's at this point.
Are you then entitled to raise it at this point?
I believe I am not entitled.
Are you then withdrawing your submission?
Upon those grounds, I withdraw my submission, Your Ladyship.
You may respond to the respondent's submissions. You have 7 minutes.
Please, Your Ladyship. In response to the respondent's submission, Your Ladyship, they submitted, and I quote, "We believe the following grounds which we think the law, Your Ladyship, we respectfully submit that this Honourable Court rely on actual law and not on thoughts." Moving on, the respondents stated in their submission that the appellant bypassed the process of the board. However, the board didn't suspend the scholarship, but the government did. Because the scheme was suspended by the government, the board would not have a jurisdiction to hear the matter. The High Court has original and unlimited jurisdiction to hear all cases as per Section 100 of the Constitution.
Now, Mr. Chen, isn't it the case that the decision was made by the board and not by the government?
Your Ladyship, the decision was made by the government and not the board. Moreover, in the last paragraph of page 2, they submitted, and I quote, "The government cannot hold the needs of one particular person." Your Ladyship, this is not about individual rights. The right to education is not an individual right. It affects all tertiary students who wish to pursue a career in medicine. Furthermore, in the second last paragraph, they submitted the example of the current pandemic. Your Ladyship, this example cannot be comparable to young people being denied the right to education. It is the right to education which determines the quality of life. Ms. Dondro has not only been denied that right, but also the right to be heard by the court. Your Ladyship, the government's decision affects the wider public. It has far-reaching consequences of these students who work day and night hard to score such marks and then denied their scholarships. This is not only about Miss Donro, this affects every young woman like Miss Donro, every young woman coming up from a similar background. My leadership, I would like to finish my rebuttal on the base that the government failed to provide compelling reasons to explain why students wishing to pursue medical and dental careers. If anything, we respectfully submit that in a time of public health crisis such as the pandemic, we need more doctors. Thank you.
You asked by Justice Devon whether the decision was made by the Board of Governors. Your position continues to be that it was a decision by government and not the board. Is that correct?
Yes, Your Ladyship.
I'll pause here for a bit. And what about if the decision were hypothetically, and I'm not correcting you or I'm not correcting or putting you to the spot, but what about if the decision were a decision by the board? Are you in the right place in this sport?
Ma'am, in that case, Your Ladyship, in that case, she would have appealed to the board since they made the decision. But in this case, the government made the decision. Therefore, she's bringing the matter to court.
I have no further questions.
Thank you, Your Ladyship.
Thank you.
Your Ladyships, in response to the appellant's submission, we the respondents so rebut. In response to the first round of submission by the appellants, we the respondents submit that the provision under Section 31 of the 2013 Constitution highlights the right to education that has been plausibly argued by the appellants is substantive, and therefore I thank them for that. However, they have failed to acknowledge subsection 2 that reads, and I quote, "The state must take reasonable measures within its available resources to achieve the progressive realization of the right." I reiterate, my Ladyships, the state must take reasonable measures within its available resources to achieve the progressive realization of that right. As alluded by my co-counsel, the Appropriation Act 2020 and 2021 distributes the allocation of funds, and the state deems it final.
I may pause you there. That submission has been withdrawn by court counsel.
My apologies, Your Ladyship. In response to the second round of submission by the appellants, we the respondents submit that yes, of course, they have the right to be heard, but it has to be done through the proper channel. We empathize with the people out there who have been affected by the non-availability of the TELS scholarship for the MBBS program, but there is a proper channel to be followed, which I reiterate before this honorable court that there is an appeals process which has been established under Section 13 of the Tertiary Scholarship and Loans Act 2014 as alluded by my co-counsel, and it does not come to court. Does the court need to rectify the appellant's argument? We propose not, Your Ladyships, because this court is not about facts, it is about law. TELS is a statutory body which regulates its own affairs, and it follows the appeals process. In response to the third round of submission made by the appellants, we the respondents submit that my clients understand they are responsible and they have the obligation towards the citizens of this country. Yes, they have ratified the Universal Declaration of Human Rights. It does not necessarily mean that my clients ignoring the obligations. They are already providing free education to primary and secondary school students. Therefore, if the state does not have the available resources, considering the interest of the wider public, the state will prioritize the rights under the Constitution, because, my Ladyships, under the 2013 Constitution, there are 45 provisions under the Bill of Rights and not only the right to education. It is therefore a humble prayer to this Honourable Court to reaffirm the decision of the High Court to dismiss the appellant's application with cause.
Now, Counsel, I would reiterate my question to you. In terms of the subject decision, what are your submissions? Your submission, your case theory is the decision was made by the board. Does the board have the powers to suspend scholarship?
No, my ladyships, the government has. The government has.
So you say board doesn't have powers to suspend. The government does. In this instance, did the government make the decision to suspend the scholarships? Or was it the board itself?
The government, it was the government's decision, your ladyships.
Counsel, I have a question. Now, in your rebuttal, you have mentioned that the state has an obligation taking into account the current pandemic situation, and the government has to also take into account the interest of the wider public. Now, don't you think that having more health professionals in the country would be beneficial during this pandemic? We are seeing around the world that health professionals at this point in time during this pandemic are at the forefront of it. So isn't it in the interest of the wider public to have more health professionals?
Based on the statistics, there are already more doctors in the country, so the government had decided to allocate the scholarship fund for MBBS towards other programs. That's why it was suspended. There are already more doctors in the country.
The position by the respondent or the state all along has been that the decision was a decision of the board, of the state. But now you just said that it's the decision of the board. When asked, you've now stated that it's a decision of government instead of the board. That unravels your entire argument. Are you going to still maintain it, or are you going to be withdrawing? Do you want to confer with your...
I seek leave for
Yes, you may do so.
My apologies, your ladyship. The government provides the resources to the board. So based on that, the board had decided to withdraw the scholarship for the MBBS program.
So you're saying it is a decision of the board?
Yes, your ladyship.
Therefore, that would lead to my question, where, because given that the board is a statutory body under the Act, can you direct the court's attention to the relevant provisions within the Act which gives powers to the board to suspend the scholarships?
Basically, Your Ladyship. My apologies, Your Ladyship. We have not provided the act, the TELS Act, with the submission.
Yes, you may not have provided it. Have you had a look at the act at the start?
I'm sorry, I cannot answer the question at this point in time.
Do you have any further submissions to make? No. Thank you, Council. Yes, thank you, Council.
All right.
Only fair to say that both teams did remarkably well under the pressure. I congratulate both the teams for putting the effort and time together to prepare for the Moot competition, putting the presentation together and presenting this afternoon. As judges, of course, we need to look at the finer details to declare a winner. I'm sorry, you're not able to. Okay. As judges, we need to look at the finer details. Can you hear me at the back? As judges, we need to look at the finer details to declare a winner of the competition. We will deliver our judgment in due course. Just some tips. Given that this is an appeal session, you would be aware that you need to show errors of law as a starting point. You cannot challenge the findings of the lower court. You cannot bring fresh evidence unless you have leave, and leave in civil proceedings possibly not permitted unless there are extraneous circumstances permitting it. I think in terms of preparation, you may have heard it many times that preparation is the key. But how do you prepare? That's something that you need to be mindful of. How to prepare is, number one, you need to be well versed with your client's case, prospective client's cases. You need to know what the facts of the matter is. Obviously, I think in this afternoon session, there's obvious confusion as to who made the decision to suspend the scholarship, and that's such a basic, because the whole proceedings is based on the decision, and parties cannot get the basic fact right as to who made the decision. Then either side, this would potentially prove fatal to either side. In terms of familiarization with your facts, in terms of familiarization with the applicable legislation, I think that has been lacking. You would want to, if you're challenging a decision, and I'm concentrating on the case scenario for this afternoon, if you're challenging a decision, the number one thing that you want to find out is where is the powers to make the decision? Who makes the decision? Where is the powers derived? Was the decision properly made?
and then you can advance your ground to challenge it. You must also be mindful of the case laws that you submit. It's always helpful to offer case laws that are applicable, not merely persuasive. And I say that because the case scenarios may differ, the statutory applications may differ. So you need to be mindful of those things. In terms of your delivery, I think both sides were very composed. You were able to answer questions that were put up to you. I think in terms of if there was a little bit more clarity in your case synopsis, I think the confusion could have been avoided. So it may not be entirely your fault this afternoon. And I think as a litigator, the one and I will give this tip to those who want to enter civil litigation or criminal litigation. When you are presenting your client's case, it's not just about you knowing your client's case. You should be able to decipher from the pleadings that have been filed, from the discoveries that have been made, what is your opponent's case, and you should be able to counter your opponent's case. Right? So those are the things that you need to, I think, as you go into private practice, or as you enter the legal practice, those are the things that you need to be mindful of, how you will, what are the things that you look out for in litigation particularly. Those are the comments from me.
Just when you're making the submissions and you're referring to particular tabs within your submission, just make sure that the judges or the bench does have the similar copy. In the beginning, while you were referring to some of the tabs, the judges were unable to, because they were not finished with the same copy of the submission. Also, it would be much easier if you organize the tabs that you are relying on, or the case authorities, and bind it perhaps properly and tab it so that it is easier for the bench to follow with you. You may be well versed with the submissions because you were preparing it. The bench would not have the time to furnish itself, make itself more acquainted with the submissions as you will. So that's it.
I'll just add to that. When you are conducting an appeals hearing, foremost, you have time constraints in terms of how much time you may be given to make your submissions. In real practice, the court has submissions for both parties. The court would have read through the submissions. So when it comes to actual appeals hearing, you, in that space of time, you would be required to present, familiarize the bench with what your case is about, what the facts are, what the background facts are, and then you delve into the main arguments where the lower court has erred. So many times you may be thrown off your submissions. You would come to court thinking, I'm just going to read out my submissions, and you may be completely thrown off by the bench with the questions, with the clarifications that they may need. So my suggestion would be that if you're preparing for appeals hearing, or for any hearing for that matter, that you know what your case is about, what the facts are.
Thank you. Very grateful to be sitting beside Ms. Devon. 20 years of experience, and she's sharing knowledge as a seasoned practitioner. I thought you did really well. I thought the question was difficult, it was to do with appeals and your first and second year students, and you have to argue an appeal. In real practice, you don't argue an appeal until you practice for some time. They will not give you an appeal until they're absolutely sure that you're competent to argue it. But you're arguing it here as a first and second year students, and obviously we're going to ask you those questions because we need clarification. It's none other than to clarify, what is it that you're saying. So I thought you did really well. Probably, like Ms. Devon said, probably not the best feeling to be constantly constantly asking for clarification for you. Not probably the best feeling, but that's what litigation is all about. We also saw that some of you, as you presented, you began to change your positions. It's the judge's role is not to, not to do that. They don't purposely, wake up one morning and say, we're going to make this person's life a living hell today. That's not their role. Their role is they're going to make a decision that will affect the two parties that are before it. And sometimes, like in this case, there's more than 5 parties involved. So obviously, they have to look at both sides. And we're constantly asking you because we're not sure. But here we clearly see there's some confusion on the facts. So if it's one thing I would take as a first year student, as a second year student, is you just have to be very open-minded. Take this as something to learn from. It may be a competition, but these are actually life skills that we had to learn on the job. It's better to have learned it as a student than to learn it on the job, because on the job means you could either have a job or you could not. And here you're learning it firsthand. And the question was difficult. It's to do with tells, and but the question is a good question in the sense that why hasn't anyone challenged government's decision? Why? You're all students here, you all stand to be affected by this decision, yet no one has challenged it. So I think the question makes us think outside of the box, and the fact that you had to come and actually present on it was good. I thought that the case law that you presented, I understand why it's persuasive, why you had to look outside of Fiji, because we don't have those challenges. Okay, so maybe someone here will challenge it one day. You'll challenge TELS, and you'll challenge them as to why they suspended the scholarship. I don't know, but the question makes you sort of think outside of the box. In terms of the presentation by both sides, like I said, in an appeals court, it's very structured. There's many practice directions. There's a time frame for you to file. You have to file your submissions. All of that comes before us, well before. Obviously here is a different setting. It's a Moot competition. For the students of this side, the reason why we had to be hard on you on the Appropriation Act was because according to the facts, that was never presented. That's why we had to keep asking, was it presented in the lower court or not? And as Ms. Devon said, it's very hard to introduce something new at an appeal level. When that, that's why we had to keep asking you, was it provided in the lower court? Also, I like the fact that you didn't lose your confidence when you were being questioned. You tried. Like I said, it's Rome wasn't built in a day. We didn't learn these lessons immediately. It took a lot of time and practice. And don't when you're being questioned, don't just change your position because we are asking you. If that's your position, you need to come up. That's the art of advocacy. You need to come up with creative ways to why you take that position. Don't change your position. We don't want you to do that. If you really believe that that's your position, don't change it. Maintain it. Okay? But when you maintain it, don't just say you maintain it. You have to come up with creative ways to support the reason why you stand for that decision. But here we saw people were changing their positions, and we understand. It's in the heat of competition. You wanted to just step back because your colleagues are looking at you. You're in a very difficult spot. Sitting up here presenting, it's very challenging.
Let's be clear, we're not asking you to make fanciful arguments. Please don't do that.
Yeah, so I thought we did quite well there when you were being questioned, but please, if that's your position that you have to take, in a court of law, you have to stand by your position, but you have to be firm. Don't just withdraw it, because when one counsel withdraws it, it affects the entire position of the case. we had, when one council withdrew it, it affected the third council's presentation. So it's a reminder too that it's already been withdrawn. So I thought you did really well, and I hope you have a good night's rest tonight when you finish from here. And I thought that in terms of the time frame, the very limited time, and perhaps maybe it was not your fault, it was the questions, and hopefully next week we'll keep improving. Yeah, we're all learning how to do this better. But thank you very much.